Welcome to the Galloway Law Podcast. My name is Thomas Galloway. Today's guest is Maura Strassberg, professor of law at Drake Law School. I asked her questions about a paper she wrote about polygamy. It is not necessary to read the paper to follow along during this podcast, but if you're interested, it's linked in the description below. Most of the conversation was about polygamy, but we spent the last half hour of the podcast talking about polyamory and same-sex marriage. If you enjoy this episode, subscribe and share with a friend. And now, to the interview. So before we get into the paper a little bit, I'd like to have you take us through Reynolds v. United States and some of the other statutes and regulations that were around that time regarding the legality of polygamy.
The historical.
Yeah, the historical element.
Yes. Okay, so, I think we have to put this in the context of the, expansion of settlement into the West, right? And you have a period of time where, you don't really have a lot of states past the, the Mississippi River. I mean, we've got Iowa, as a territory for a good period of time. And so, some of these states start to come into the Union, but you have a vast area of the Mountain West that's a territory. And as a territory, it's governed by Congress. So there's no state government, doesn't have, states' rights. It's completely governed, by congressional statute and governors appointed by Congress. So during this period, you have the development of the Church of Jesus Christ of Latter-day Saints, the Mormon religion. Part of this period of time in which there was this huge religious awakening and sort of explosion. You've got the Shakers developing. You have all kinds of religious communities developing all over the country. The Amana here in Iowa, and so this is just one of many sort of new religions that are appearing during this time. It happens to be one of the more successful in the long run, and so initially they're settling in various places in the settled the states, including right around the Mississippi here, and the introduction of polygamy to the Church of Latter-day Saints was wasn't something that it began with. It was the prophet got a message in a sense that this is what he should do. He should establish polygamy as part of the religion, and it becomes a very central part. It has a lot to do with the sort of the theology of the Mormon Church, which is that God was once a human being in some sense, and rose up, in the same way that Jesus Christ, sort of is both human and divine, but that this is possible for every man to become a god, in a sense, and that arises out of the creation of a bloodline of people over whom one has divine power in some sense, and that the kingdom of heaven, this is the kingdom of earth and the kingdom of heaven, that what you build in the kingdom of in earth becomes your kingdom in heaven.
Right.
And there's also a sort of a normative aspect that having children creates a place for souls to be brought to life again, in a sense, and that bringing them into a Mormon or a Church of Latter-day Saints household where they're going to be raised that way is going to ensure that they will go to the highest level of of heaven. So this heaven has all these levels, and if you're a Mormon and you're properly married in a Mormon church and you're raised that way, and you're going to end up at the highest level. And if you're not, you'll be somewhere below that, if in heaven at all.
Right.
So there's a lot of theological impetus that is going this way. And why it was that Brigham Young decided that there should be, or Joseph Smith decided that there should be polygamy. A lot of historical argument about whether it was his own sexual proclivities or something else more divinely inspired. But it certainly took off and became a central part of sort of Mormon religious practice. But doing that in a sort of monogamous, non-purely Mormon setting created a lot of hostility.
Right.
And so they were essentially run out of, I think they're in Gutenberg maybe, attacked. And this triggered the long trail out to Utah where they settled. But polygamy was a central aspect of the religion. And even today, the Mormon Church repudiated polygamy in about 1893 because essentially it was running for its life. I mean, Congress finally figured out that taking away its property, basically taking away its ability to be a legally recognized corporation and own property, would really hurt, and it did. Right. And they backed away. But it's not that it's not theologically still justified. It's just been decided that it's not necessary to do.
Right.
Right. It's not required, but it could at any time become something that is viewed as necessary and appropriate. So it's so that's the Mormon Church's relation to polygamy, which is the background for Congress enacting laws that once they realize, okay, so the Mormons have gone out, they've settled Utah, they're a majority of the citizens out there, although not completely, and as a result, and they've sort of have a lot of the control over civil institutions, they're able to engage in these polygamous marriages, actually legal marriages. They simply decided, okay, we can legally marry more than one person. And so Congress enacted the first polygamy law, the Edmunds Act. I think that was the first one. Actually, I have to consult my article, but these details are not so important. Right. The first one, which said you couldn't legally marry more than one person, and that's what Reynolds was prosecuted under. He, it was. They didn't have a bigamy statute in the territory because it was then just a territory, and Congress might not have had any laws about marriage because, again, that was a state, it's the states that legislate marriage and control marriage. That's part of the police power that's reserved to the states. So they were kind of free to do what they wanted in the absence of some federal statute there. And so Congress enacted statutes saying you can't marry more than one person at a time. Right. And Reynolds had legally married more than one person, and so it came to the Supreme Court. And the Supreme Court, I mean, if you read the Reynolds case today, you're struck most by the incredible racism of it. Right. And that and subsequent Supreme Court opinions in the late 1800s. This one talked about it as an odious practice that up till now, until the Mormons took it up, had only been practiced by Asiatic and African people, right? And sort of contrasted it to Western civilization. References to barbarism. Later opinions talk about sort of Christianity. So there's a whole very simple say, hey, this is not our culture. And we can reject this simply for that reason. Right. But it wasn't strictly that. There was also another layer of argument in Reynolds, and it's hard to make sense of exactly, but it's derived from a sort of political science philosopher named Francis Lieber, who had come from Germany, had been educated at at the time Hegel was teaching in German universities. And Hegel had done a lot of taken a lot of anthropological information, what we would see as anthropological information today, and sort of incorporated it into his vast philosophy of everything and why it all happens the way it does. And Lieber had certainly picked up on that, had learned about this information. What I'm talking about is Jesuit priests going off to China and sending back reports on lifestyle and politics and everything in China, which included polygamy at that time. And Hegel had come to the view that polygamy was, that marriage, he had a whole philosophy of political philosophy, the philosophy of right, which involved sort of building up to civil society through private relationships, that marriage was not just sort of personal, and about sex and having children and, sort of necessary in those ways, but that the marital relationship and the state's involvement in the marital relationship was part of creating a civil society in which people could understand that their participation in a broader polity was not suppressing their individuality, but making it possible, right? And so the marriage relationship, here you are, you're two individuals, you do what you want, you get married, and somehow you manage to find yourself even more so in this relationship. There's more freedom, even though there's constraints. Marriage is definitely constraining, but it sort of teaches a lesson of social transcendence, that pure individuality, pure narcissism is not ultimately as fulfilling as being part of something that's intersubjective and social. And that, of course, that makes possible ultimately being in a society which has all kinds of laws which limits you in any number of ways, but yet seeing this as preserving your freedom, creating and preserving your freedom, right? So it's the state of nature versus the society of laws, and how to understand why we come to prefer the society of laws. Right. So Hegel has this, incorporates, and he's really, I think, the first to take marriage as a political institution seriously. Right. Other people had certainly talked about it. Rousseau was interested in it, but I think he creates this structure in which they're linked in very important ways. Maybe he might go beyond what we would be willing to go beyond, and he certainly had an extremely, heterosexual, sexist view of marriage, and he thought women were more like vegetables and men were more like animals. He had some crazy ideas, to say the least. But so this Francis Lieber had adopted a good deal of these notions, not as much of Hegel's sort of metaphysics and such, but he sort of developed this notion of the relationship between forms of marriage and the kind of society, the kind of political structure your society was. And so his view was that polygamy was linked to despotism. Despotism meaning the authoritarian rule of one person who had complete power, uncontrolled power by a constitution, by a legislature, by anything. I'm thinking of the Saudi prince right now, right? In that sense, and so what's the link between polygamy and this political form? Well, the link is that polygamy was linked to despotism. So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's the link between polygamy and this political form? So what's Well, polygamy, and we're always talking about polygyny, right? We're talking about one man, multiple wives, right? Because there is, practically speaking, no polyandry in the world. There's a little bit in Nepal, where two brothers might marry a single woman, mostly because the land can't support too many children, right? So that you sort of you concentrate your genetic heritage in the children of one woman. Right. But it doesn't work out any better for women. They don't have more power in the situation. So either way, doesn't seem to be a good setup. But anyway, for the most part, we're talking about polygamy. And so you have, basically you have one man who's sort of at the top of a pyramid, right? A pyramid of wives and a larger base of children. And the interesting to think about, for us to think about, we're not used to polygamy, but the idea that fathers are competing with their sons for wives, right? That you'd have some 50-year-old, some 60-year-old, and he's marrying some 17 or 18-year-old, and where does that leave his 40-year-old sons and his 35-year-old sons and his 25-year-old sons and his 18-year-old sons, right? They're not, insofar as they're part of this common enterprise and still sort of under the thumb of the father and economically sort of contributing to the family, trying to build up their own wealth to start their own pyramid. Right. It's not so easy for them to do. Hard to compete with somebody who's got all these resources feeding their power. And just from a familial perspective, if you try to imagine, you have this one father who's, there's one father, tons of kids, lots of wives, and, the father is the one with the power, Right. In some sense. On the other hand, the reality of polygamous families is the father's, not around very much, and the mothers are running the show. Right. But there's something to being the only one. It has a impact, and they're the ones who sort of decide who gets what. So, how is that connected to despotism? Well, you could see, on the one hand, you have this sort of proliferation of individuality, many different centers of control. That's monogamy, and the monogamous family is just kind of weak. Right? Kids grow up, they leave, they establish their own families. They have emotional ties to their parents, but it's not like the family has you. Right. Some sort of grasp. Right? And so it's the weakness of the monogamous family that is both the good and the bad. Really the good of it in some sense, because it lets people out into civil society. And lets those other structures become more important. Right. It also, I think, Hegel was of the view, and Lieber would probably agree, that notions of equality come out of monogamous relationships in a way they don't out of polygamous. And that is, there's just one other person, right? When there's just one other person, then you are somewhat equal, even when your legal status in society is very different nonetheless. Right. 1 + 1 is an asymmetrical thing. 1 against 2, 1 against 3, 1 against 4. How can you be equal when you're not enough? Right? You're insufficient for this one husband. Right? They need somebody else. And so there's a message of inequality. There's a reality of inequality. You don't get the full attention of that person. You don't get the full resources, and so it's just fundamentally not creating this, this foundation for some sort of gender equality. Right. And then, of course, if what you're going to do is get married, be one of many wives, and have lots of children, then there isn't a lot of need to educate you. Right. And you're going to be pretty ground down by taking care of all these kids in the absence of a father/husband who's really fully committed to your children
Right.
and you. So, gender equality issues, sort of political structure issues. So anyway, the Supreme Court picks up on this in Reynolds in a very elliptical way. It's not so clear what they're talking about. You have to. They do, I think, mention Lieber briefly, but it's like they just sort of say, "Oh, this is more likely to lead to despotism," and society has a lot to deal. Is going to have to deal with the whatever it is that polygamy produces, social relations, etc. That we would have to deal with this, and then it also talks about what impact a community of polygamists might have in a larger monogamous society, just suggesting that it might have an impact. It might sort of stay contained for a while, but it's not likely to. But this all happens in 2 paragraphs.
Right.
Right? Just not much.
Right.
And I think, perhaps very easy at that time, a lot of, social horror at the idea of polygamy made it easy for the court to just sort of tap into that, say a little bit, and move on, right? And there wasn't a lot of uproar in relation to that. And that stayed the same for, there were a couple more polygamy cases that came to the court as Congress shifted the laws so that they weren't strictly aimed at people who legally married each other, because as soon as that became illegal, they, stopped legally marrying their second and third wives. Or at first they started simultaneously marrying 2 people at once, because then neither one would have been married before. That didn't work. So, they evolved ways of continuing their polygamous practice, which was very religiously important.
Right.
Don't want to in any way downplay that. And so the laws had to evolve with that, and so periodically something would come to the Supreme Court to sort of resolve, whether the laws properly covered the conduct that someone had been arrested for. And then the Mormon, then they dropped polygamy, and it didn't mean it was the end of polygamy, but those who insist upon being polygamists, they moved down to Mexico. For a while, they sort of went out into the more isolated parts of the state, or this polygamous community that grew right on the border between Arizona and Utah, Idaho, up in Canada. So it became something that it's kind of little pockets of people who were outlaws, but mainstream Mormon society became monogamous.
Right.
And so there weren't a lot of prosecutions. Things weren't going back up to the Supreme Court anymore. It was sort of over.
Right.
In that way. And then we come to modern times, right? In modern times, we have a development of our First Amendment freedom of religion jurisprudence, which becomes much more protective of religion, non-Christian religion, as and then which of course turns around and protects Christianity as well. But so we have this burgeoning First Amendment jurisprudence. We have changes in sexual mores, where you have divorce, multiple marriage, serial polygamy, right, where people don't live, they don't have multiple wives at the same time, but they, marry one, they divorce one, they get married to somebody else, maybe as many times as they can manage in their life. Hollywood stars, Howard Hughes, Donald Trump. So, the question is, what's the difference? Why is that okay? Mm-hmm. The idea of divorce becomes acceptable in a way that it wasn't, hard for us to imagine, but really wasn't acceptable before. And then, then adultery laws come under attack, and, why do people have to be married to have sex at all, both from the perspective of people who were never married in the first place, fornication laws. And so the whole sexual aspect of polygamy, it's bad for someone to have sex with more than one person, right? Becomes something that we're just sort of a little less convinced of.
Right.
And then you have the development of gay rights movement and, the decriminalization of same-sex sex, and ultimately the recognition of same-sex marriage. That's really why I came into this, because it was in the 1990s. Justice Scalia had written an opinion, a dissent to the first positive gay rights case that came out of the Supreme Court, which was Roma versus Evans. Right? So the negative case was before that. That was the case that said, it was okay for Georgia to criminalize same-sex sex. But several years after that, Colorado enacted a constitutional amendment which prohibited localities, anything larger than the state, from protecting rights based on sexual orientation. Mm-hmm. So it prevented a college town from Boulder from enacting a civil rights ordinance that would protect same-sex couples or individuals. And basically on a statewide basis said, look, you can in no way consider sexual orientation as a problem, as a basis for discrimination, right? Which means you're actually saying, go ahead, discriminate. It's fine. There's nothing wrong with it. Anyway, the case went up to the Supreme Court, and the question was whether it violated the 14th Amendment, equal protection of the laws, to sort of make it impossible for people to petition their local government for recognition or to be intentionally discriminated. And the majority of the court found that this law reflected animus toward gay people and struck it down as unconstitutional, even in the face of having previously said it was fine for a state to legally make same-sex sex criminal. Right. But this wasn't about sex, right? This was just about status, which made it a little easier for the court to take this step. Right. And Scalia wrote a blistering dissent to this opinion. And one of the things he said was, well, if the state doesn't have a right to sort of morally disapprove of somebody, or someone's actions in this way, then how are we going to justify state criminalization prohibitions on incest, on pedophilia, on bestiality, and of course polygamy, right? The parade of horrors, right? Oh, now that you've done this, everything else, you've opened up Pandora's box, and this is all going to have to be legalized because this is discrimination too, right? And I'm a gay person. I was very appreciative of Roma versus Evans. I wanted same-sex marriage to be legalized, and I read this and I thought, well, what about this polygamy thing? I never thought about polygamy. Didn't grow up in the Mountain West. Right. And I thought, well, okay, so does this, if I support same-sex marriage, should I also support the decriminalization and the recognition of polygamous marriages? Let me think about this. Right. Is this something that I would agree with him on and say, in a sense, yeah, okay, we should open the door to this at least, or we shouldn't, right? And how am I going to distinguish? I certainly understood that this throwing polygamy in with same-sex marriage was not helping same-sex marriage. Right. But I didn't know whether that was because polygamy was misunderstood or because it was different. Right. So, I mean, that's what I undertook to think about when I first started writing about it. And this article, which was published in 2015, this is like one of 4 or 5 articles. It's the second to the last of the articles that I wrote on polygamy. And I started off really just asking, what is the difference between monogamy and polygamy and same-sex marriage, right? Are those distinctions that are significant and justify treating polygamy differently and same-sex marriage differently from polygamy, but more like heterosexual monogamy, and so it's really ultimately about monogamy versus polygamy, or not. What's the case for this? And so of course I started with Reynolds and the jurisprudence that existed, and it was fairly terrible. I mean, except for this point about despotism and such. And certainly if that's true, if polygamy does lead to a social order that's completely inconsistent to what our constitutional order has created and the principles of equality and liberty that we've embraced, then of course it makes sense that we wouldn't want it, right? That's a pretty significant thing. The problem is, as enamored as I am of Hegel and philosophical sort of speculative anthropological understandings, I mean, I could and did spin a long tale of differences from that point of view. It's not really empirical,
right?
And it's pretty heavy stuff. Hegel, anything based on Hegel is pretty heavy in that way. It's interesting and intriguing. Might be right in some ways, but it's not exactly an argument you can really bring to a court.
Right.
So I did come up with a lot of arguments about why, and I've sort of spelled out some of them to you a little bit about the structure of monogamous relationships versus polygamous relationships and how that can affect individual development and political sensibility, shall we say. But it's not something that I really thought could ever work in a court, right? But here you have, this is what Reynolds is, if it's based on anything real, that's what it's based on.
Right.
Because the other part is just, racist. And sort of, Western, anyway, so I mean, I struggle to sort of try and make a distinction. I mean, ultimately, and people have gone 2 different directions. Some people have gone in the direction of saying, yeah, well, polygamy should also be legalized. That this is just as illiberal and bad as the persecution of gay people. And I end up going the other way, which is a difficult position to take. I mean, it's much easier to just be sort of like, oh yeah,
right.
Let's not make any distinctions like this. But I felt that there was some legitimacy to this, but I had a hard time putting my finger on what it was going to be, right? And there was sort of a lot of anecdotal reports about some very bad things that were happening in polygamous communities in terms of sexual abuse and marrying children off against their will at very young ages and such. But connecting that in some kind of necessary way to polygamy was problematic. And there were anthropological studies of other polygamous communities in which there certainly were positive family relations and things were good for women in some ways, sister wives and sharing the burden and only having a part of a husband to deal with, had their positive aspects to women's lives. And takes a village to raise children. Well, there you had your village right there. So and of course, you have people who are committed to the religious value. I mean, it's fundamental to their salvation that they are in these relationships. And so that makes it, something that is a lot more positive no matter what's going on.
Right.
But anyway, there's sort of a feminist case for polygamy. And I did want to keep my eyes wide open and not be, as prejudiced as the Reynolds Court
Right.
was, and just saying I don't approve of it, so I'm going to take this position. So I did read these accounts and try to take them seriously. And so there was a period of my scholarship where I was trying to make these arguments, but it was hard to make the kind of arguments that would, I think, be really have some weight in a modern court of law. And then came along this Canadian case, which is what the article that I pointed you to read
Right.
was about. And the Canadian case reflects the same thing happened in Canada, that Canada has a fairly new constitution, its charter, and adopted mid-19th century, and it was easy to interpret in very liberal, progressive ways because it was written that way.
Right.
Didn't have to work so as hard as we've had to get there. And so at 2011, someone challenges the criminalization of polygamy under the Canadian Charter, and of course it's a new question for them. Everything's a new question for them. They don't have this history that we have, precedent. And they also have a mechanism which we don't have in our system, which is the ability for a question to just be referred to a court, a constitutional question, and for the court to hear this without an actual plaintiff and defendant.
Okay.
So there's no person that was being actually prosecuted whose case was being these issues were being resolved through this case.
Right.
We have a case or controversy requirement. Our courts can only hear cases or controversies, so we can't just say, "Is this constitutional?"
Right.
You have to get somebody for whom that becomes important to their liberty or other interests. And so this British Columbia court gets this question, this reference, and proceeds to assemble people, to take both sides, right? So you have the government defends its law, but the court appoints amici who represent the other side, on both sides, but they're people who are defending, who are attacking the law,
Right.
taking the position that it is a violation, and they bring experts in, and all the scientific literature, the sociological literature, the psychological literature, the anecdotal literature, people who've testified, Warren Jeff's, former wives, and you name it. If it was relevant to the question of polygamy, it got brought before this court.
Right.
And some really interesting statistical work that looked at 172 nations and sort of data about women and children in those nations, and was able to then correlate that with the presence of polygamy or not, and sort of to see what impact polygamy as a legitimate practice in a society had on the status of women and children, in a variety of indicators. So, all this testimony produced for this court what it thought was a strikingly consistent result, that no matter whether you looked at it at this very large scale statistical analysis, or you brought it all the way down to particular anecdotal accounts, wherever you looked, you were going to find that women and children were particularly harmed by the practice of polygamy.
Right.
And it really wasn't so great for men either. I talk a little bit in the article about the cruel arithmetic of polygamy,
Right.
where you postulate a society of 40 people, 20 men and 20 women, and you've got people from, some people have more money, some people have less money, and the people with more money are the ones who can marry more than one wife.
Right.
So you take 25% of the men, right? They marry, a bunch of them marry 2 women, a couple of them marry 3 women, and one marries for women, and out of this you end up with let's see what I mean, just to get my numbers correct. I want to be accurate here.
It also mentioned that sometimes up to half of the men end up out of the community.
Yeah,
altogether.
first you'd have like 40% of the men who wouldn't be married, right? I mean,
Right.
just it doesn't take much
Yeah.
for a lot of men to be deprived of partners.
Right.
So you have this pool of unmarried men, and these are the men who have the least resources in the society, right? Going to be least wealthy, least educated, least skilled, and they can't get married. They
Right.
can't have kids. You know, what's that gonna do for, you know, their life and society when you've got this pool of men who are in that position? And you know, some evidence that you've got more repressive governments. I mean, you know, they have a social problem in some sense. You've got countries that are more likely to be engaged in war.
Right.
Because here you have this pool of unmarried men. Well, maybe you better put them in the army, and you know, to keep control over them, and then channel their aggression and
Right.
and frustration, you know, externally rather than internally. So that's on the men's side of it. You know, on the women's side of it, you've got children whose the resources for taking care of them has just been spread extremely thinly.
Right.
I mean, you know, take somebody who can, you know, provide decently for one or two children, and you give them 20, and
Yeah.
the kids are not getting anything from the father. In fact, the father is saving his money for his next wife.
Right.
Right? So the investment in children, why invest in children when you can just have more?
Right.
There's no need to, and no motivation to do it. So not a lot of investment in children. Obviously not a lot of attention from the father. And you know, poverty.
Right.
You know, the GDP of these countries is less than if they were to become monogamous. There would, you know, be very clear effects on the GDP simply because people would spend money on their families instead of buying wives.
Right.
So and then there's the effects on women. Women are, you know, because there's competition for women, right? It becomes sort of commodified. And the competition produces a need to marry younger and younger women, because the pool, to keep expanding the pool, you have to keep dipping deeper into the age range of who's available.
Right.
And so you get marriage at very young ages, which means you're not going to be educated. It means you're going to start having children when you're fairly young. You're going to have lots of children because that's what you're going to do. Not good for women physically. Not good for them economically. You know, from a mental health perspective, they're, you know, somewhat powerless, fairly burdened, don't have a lot of support, except maybe other sister wives who may or may not be in competition. You know, sometimes you can have a nice situation, and sometimes you could have a not very nice situation. Right. So a lot of negative effects on women, and you know, interestingly, going back to this sort of, you know, more philosophical notion that monogamy reflects some sort of gender equality, that it pushes toward gender equality, even though it certainly wasn't a very equal institution for much of its existence. It has a natural push toward equality.
Right.
You see that the legal status of women in these countries is markedly worse than the legal status of women in monogamous countries, right? I mean, so you have this statistical evidence, and you know, you can't say causally, okay, this is what causes it.
Right.
I mean, statistics doesn't show you that, but you know, some pretty striking evidence, and it, you know, I mean, it's all being analyzed by an economist who's, you know, controlling for the effect of more and less resources. So polygamous countries are poorer countries. I mean, that's also maybe a consequence of the polygamy, but even if it's not, some control for the fact that, that the developed world is less polygamous than the undeveloped world. So anyway, ton of evidence. The court concludes that even though this does substantially infringe upon religious liberty, this criminalization of polygamy, that it is consistent with the charter. At the same time, approximately the same time, we have a case here in the United States, this Utah case involving Cody Brown and his family, which is poorly litigated by the state of Utah, and if a federal district court saying essentially that Utah, which has a law on the books which prohibits both legal multiple marriage and attempts to marry without involving the law, avoid that by just cohabitating as man and wife, has had this law on the books since its founding because it had to. It's written into its enabling ordinance as a state. This court takes a look at the polygamy law, looks at the rather impoverished justifications stemming from Reynolds, through modern time, that have been provided for the law, and says, hey, this can't withstand our modern, free exercise jurisprudence. It can't withstand our modern, 14th Amendment jurisprudence, and sort of splits the baby. Can't quite repudiate Reynolds because it's a lower court, and the Supreme Court not only is that a Supreme Court precedent, but it's been cited approvingly through modern times as an example of a situation where sometimes the social harm is so great that even an infringement on religious liberty is permitted.
Right.
So doesn't attempt to strike down the prohibition on multiple legal marriages, but does say that the prohibition on cohabitation in a marital cohabitation is illegal. Right. And ultimately that gets appealed to the 10th Circuit, and the 10th Circuit strikes the whole case down as moot because Cody Brown is living in Nevada, and the Utah Attorney General says we won't go after people in this situation. So as a precedent, it's sort of not. It doesn't have real precedential value, but it was the first successful attempt to defend polygamy in the courts, really. But the problem was none of the evidence that the Canadian court had in front of it came to this American court, right? They just sort of had some old hack arguments that weren't very good, and were good enough in the old days, but aren't so good nowadays.
Right.
And so the question is, if we took this evidence, what's available from the Canadian case and applied it to our own constitutional evaluation, how would things come out? I mean, personally, I think we wouldn't even need to get to strict scrutiny, because I think the Utah court did some things that allowed it to claim that this was religious discrimination in a way that I don't think it really was. I mean, were the laws motivated by the reality of the Mormon practice in the 1800s? Yes. Does that mean that they are written in such a way that they're actually religiously discriminatory? No, I don't think so. I think that anybody's marital cohabitation is caught under these laws, just as anybody's bigamy, whether it's religiously motivated or not. But that's part of a complicated parsing of the whole decision.
Right.
So I don't know. I talked for a long time. You haven't asked me a question.
Well, in the Brown case, in addition to the free exercise clause, they also mentioned the Smith hybrid rights analysis framework and the due process clause. Could you go through those two a little bit and why the Browns felt like they were relevant to their case?
Well, the due process clause, that's the 14th Amendment.
That's for the 14th,
and that's
okay.
so that's just equality, right? And non-discrimination. So I think the question of even so, we're sort of that was before the Supreme Court had recognized same-sex marriage, right? So it was before we got to a point where we knew that perhaps we would have some kind of higher level scrutiny for sure, because marriage was involved, maybe, or so the court in Brown for the due process argument sort of hit all bases, rational basis. So there's technically sort of three levels of scrutiny that the court has described itself as doing sometimes, which is rational basis, which means if a legislature could come up with something which could be a rational basis, we would approve this law, even if that wasn't why they did it.
Okay.
And that's for a situation in which we have no reason to think there's any discrimination going on of the kind that worries us. I mean, laws make discriminations all the time. They classify and say you can do this, or you can do this kind of thing and not this kind of thing, or if you're 18 you can drink, and if you're not 18 you can't, right? I mean, discrimination is what laws do, but unless we think there's something invidious about it, we're not going to look very closely at it. We're just going to make sure it's not completely arbitrary and makes no sense. If we think that something is potentially invidious about it, and we have certain things that we worry about. Obviously, we worry about race. We've come to worry about sex, but only in a sort of moderate way. We're not entirely convinced that every discrimination based on sex is improper. So, there's this notion of intermediate scrutiny. We'll look at it and make sure that it's more than reasonably related to its goal, that it has some justifications that are not just theoretical but actual. And then we have strict scrutiny, certainly for race, which is to say that you have to have a compelling state purpose, and the rule has to be narrowly drawn to achieve that. And if the purpose isn't compelling or it's not narrowly drawn, then we're going to think this law is enacted in order to promote discrimination.
Right.
So we have these three different levels, and the court, not knowing which level really applied in this situation, sort of went through all of them and said, well, these justifications, there's just nothing there.
Right.
It doesn't matter what level of scrutiny we apply. I don't even think this can pass rational basis scrutiny, let alone the highest level of scrutiny. And in some ways, it was right, because the case had not really been created. I mean, we're just kind of resting on this old, rather confusing and problematic decision. So that was the 14th Amendment argument. The problem is no compelling state interests were really articulated, nor was any evidence presented to show that there was a link between polygamy and the kinds of things you were trying to prevent, whatever the harm was of the law. So you have to identify what are the harms, and the fact that the harms are actually caused by this practice that you're regulating, in order to have any kind of fit between the law and its claimed purposes. So this is where the reference case comes in, as providing this articulation of what the harms of polygamy are and why we should believe that they actually are related to polygamy. The hybrid analysis is sort of the truth of the matter is we're not even sure that the hybrid analysis really is, going to have any staying power. It was a way to explain the results in some cases that otherwise seem kind of hard to justify. And that is, there were some freedom of religion cases that we might have said involved a fairly compelling state interest, but the court basically said, yeah, we're gonna say that this is a violation of their rights. One of them is it's Yoder versus Wisconsin,
right.
which is the case involving Amish children who were required to go to school past the 8th grade under state law, but their community didn't want them to go to school past 8th grade because that would involve them too much in the world in a way that would make it hard for them to stay in their communities.
Right.
Sort of in retrospect, this was justified on the grounds that there were parental rights. If there's more than one set of rights, it wasn't just freedom of religion, there was also parental rights involved. So, there were a couple of decisions that kind of went the other way in terms of saying they were infringements on religious freedom in a way that, well, I have to back up a little bit. Why do we need that justification? It's because under Employment Division versus Smith, the court came up with this rule that said basically if you have a law that's generally applicable to a lot of people, that's neutral and generally applicable, the fact that it happens to impinge upon some religious practice is not a problem. Mm-hmm. That's not going to be a violation of freedom. So, murder, right? We have a law that prevents you from murdering people. If you have a religious practice that involves human sacrifice, that's going to affect you, right? We're not going to say that that's going to be a violation of the Constitution because the law was not designed to particularly target your human sacrifice. There's a broader purpose to it. It happens to, and prohibition and the use of wine in ceremonies. The Employment Division versus Smith was about peyote, right? And the fact it was a religious thing for the two Native Americans that were prosecuting the case, but generally there were other state interests that were involved in criminalizing the use of this drug and creating certain consequences for using it, and it wasn't. It happened to have an effect on religion, but it wasn't aimed at religion.
Right.
So the hybrid analysis was an explanation of cases that otherwise involved generally applicable and neutral laws, like everyone has to go to school through age 16 or something like that, right? It's not aimed at the Amish community.
Right.
It would pass the generally applicable and neutral law, but the court came out with a different result, and we have to explain how. So the argument was, there was more than one right involved. There was not just religion, but parental rights or something else, and so that sort of upped the ante in some way.
Right.
It's not a very good argument, but it's what's been used to kind of make sense of those cases.
Right. So then, to get strict scrutiny applied, you would have to show that a law was not neutral and not of general applicability. Is that correct?
Right.
Okay.
And so you do have cases where the court has found this. There was a case, the Hialeah case, involving the city of Hialeah enacted a law that prohibited the sacrifice of animals because there was a Santeria church that had established itself and was engaging as part of its religious practice in some sacrifice of animals. And, they didn't like it, so they enacted these ordinances that prohibited that, essentially, but pretty much let everyone else kill whatever animal they wanted for whatever other purpose they wanted, whether it was killing a rat in your house or shooting something for sport or slaughtering it for, kosher slaughter or any other slaughter or, generally we don't have a lot of problem with the killing of animals, and the law just kind of zeroed in on this one practice, picked it up, and said, you can't do this. But everything else like that, well, that was understood not to be a neutral or generally applicable law.
Right.
And therefore it did violate freedom of religion, free exercise of religion.
Okay.
So the question is, do our polygamy laws, are they really about Mormons?
Right.
And the religious, is it really a picking on this religious practice of polygamy? And if we were to engage in strict scrutiny, of it from other perspectives, even if we weren't intentionally picking on it. I mean, if it was, if it pretty much had a burden on them in a particular way, then it would be problematic.
Right.
Or is it about polygamy?
Yeah.
Not religious polygamy. It happens to be in our country that well, I mean, up to this point in time, that Mormon polygamy might have been the most visible and coherent presentation of polygamy in our country. You do have people who come from countries where it's culturally accepted who are in fact engaging in it.
Right.
There's a whole something of a movement, over the past 30 years or so in the African American community due to the lack of available men, due to the incarceration of so many black men, that to promote polygamy as a way of sort of stabilizing black society, so you don't have all these unmarried women with
right.
children. So I mean, that's been there's been a sort of a force in that direction, very different thing going on there,
right.
for sure.
Yeah.
And then you have polyamory, which was my other thing, right? You have this new institution of which is the essence of liberality, right?
Right.
It's not gender specific. It's not it could be gay or straight. It's sort of sexually fluid potentially.
Mm-hmm.
These multiple relationships, this multi-people marriages, perhaps even. It
Right.
doesn't have to be that level of commitment. And so that was the other thing that I explored a little bit, was to think about polyamory, and if I was going to be willing to support the criminalization of polygamy, what did I think about polyamory, and could it be distinguished practically, legally? Should it be? Because I think a lot of people are negative about the criminalization of polygamy and the non-recognition of polygamous relationships, because actually they have polyamory in mind.
Right. Yep.
And they think, well, why not? If you can have a same-sex relationship, why can't you be involved with more than one person? What's the problem?
Right.
Right. And I certainly get that. And it ideologically, it's so different.
Yeah.
Right. From a gender equality perspective and a sexuality perspective, it reflects some things that are very contemporary in our society.
Right.
And I, in fact, don't have a lot of problem with it, except in one way, and that is there's no limit on the size of polyamorous relationships. And I think that you get beyond, say 4 people into 5 people, and you get some interesting power dynamics going on. And you may have situations where people are really caught in a situation that, you sort of, at a certain size you hit cult level,
Right.
right? And sort of, how do we sort of make sure that people don't get sucked into this social structure that is ultimately not easy to maintain your individuality and your sort of your own power,
Right.
and without maybe unnecessarily limiting people. So I mean, if I wasn't worried about polygamy, I would say, okay, 3-4 people, I'd probably be fine with that.
Right.
But I think legally it's impossible to distinguish polyamory from polygamy. I mean, because some polyamorous relationships might involve one man and multiple women.
Right.
They might involve one woman and multiple men, or equal or somewhat equal numbers of men and women. But I don't think legally we can distinguish between the polygamous relationship, which is hierarchical and which is part of a structure that always limits it to one man and multiple women,
Right.
from something that just happens to sometimes look like that.
Right.
Right? I mean, don't know how you can do that legally.
Right.
And so polyamory is sort of stuck, I think, in certain ways, as long as polygamy is real.
Mm-hmm.
I mean, if we ever got to the point, if we evolved to a point where polygamy couldn't be real, right, then I think we could rethink it.
Right.
But we're not there.
Right. So with polyamory, you don't have the same issue of multiple legally recognized marriages that you would have.
Well, you
with
could.
Polygamy.
No, you could absolutely.
With polyamory.
I mean, sure, if people wanted to,
Right.
if you had, one woman and two men, let's say, and they each wanted to marry each other, so
right.
The woman would be married to both men and the men would be married to each other, right? Or they, that would set up a bigamy situation, right? That would be legally impossible to do right now.
Right.
But notice one of the interesting things about polyamory is that it can be complete. You can close the circle, maybe, depending on the relationships, actually.
Right.
But it has the potential in which everybody is equally related to everybody else, as opposed to everything funneling up to one person, right? Because the wives in a polygamous relationship are not married to each other.
Right.
They may or may not have some choice as to who becomes a wife, but they don't have that same bond.
Right.
And so, polyamory has the possibility of that, but it isn't necessary. I mean, you might have one woman and two men, and they might not have that same relationship.
Right.
So, it's, I mean, right now, the polyamorous community, some of them would like to have multiple marriages. I mean, there's legal protection in marriage and legal benefits to marriage. And so, somebody's left out of that if you're polyamorous. And that, it is problematic.
Right.
But it's, exploring that possibility is, for me, hemmed in by the consequences it would have for polygamy.
Would you say that the general motivations or cultural factors affecting polygamy are different than polyamory?
Completely. I mean, that polygamy is polygamy understood as polygyny, right?
Right.
Meaning limited, one man, multiple wives. I mean, it's old world.
Right.
I mean, it's rooted in really patriarchal notions, right? In which somehow men are distinctly different from women, in very important ways. And polyamory is rooted in, super modern, progressive, gender fluid, sexuality fluid notions, right? So it doesn't worry me in the same ways. I mean, understanding really what would a society that was like that look like, and what it's hard to. There's no lab, right? We have the polygamy lab, right? We got 107. We have all these countries in which some of which have polygamy and some of which don't. So we have a laboratory that we can study and see, well, what is it doing? Mm-hmm. There's no polyamorous society. I mean, there's people here and there who are living their lives that way, but what would it look like? And it's not dissimilar to the questions that people had about same-sex relationships. What's the impact going to be on society, and is it going to really completely change everything and undermine our way of life and such? But you did have a lot of people, a fairly large contingent of people who were living as couples, even if they weren't legally married, and you could kind of see how it was going, what effect it was having on things. I mean, polyamory is just harder because, gosh, it's hard to be polyamorous. It's hard to find one person you can fall in love with. Imagine finding two or three who you fall in love with and they like each other or fall in love with each other. Right. It's just it's not so easily going to be a mass movement. I think. And then, sort of trying to appreciate, okay, what is this? What are the social impacts of this? What are the political impacts? Are there any? I mean, it's new. We don't really have a feel for it in that way. I mean, I don't, I think it could be a feature sort of the future. Maybe. It sort of depends on how well it really does meet people's needs.
Right. I have a bit of idealistic view of polyamory in that the difference in motivations behind it from polygamy could make it feasible. Like you said, we really don't have a whole lot of idea what if it's possible. Would you be optimistic, I guess you could say, about it, that? Or is it just impossible to tell?
No, I mean, first of all, it has to be practically possible. I mean, people have to be able to live that way, right? They have to, jealousy is the big issue in the polyamorous community. I mean, I spent a year reading, Loving More, which was the magazine of the polyamorous community, and all the stuff that was out there, and websites and such, and jealousy was just like that's the enemy of polyamory, and I mean, they have a whole view of jealousy as being negative and unnecessary, and there's loving more. There's always enough love for everybody. It's not a scarce commodity. Well, human beings have to actually get there. If that's maybe that's true, maybe it's not true. I mean, how consistently can we do that? And I mean, maybe we evolve ways of being in relationships in which this becomes less of an issue. But I don't know. I think it's a pretty real problem. So that's an internal problem for the polyamorous community. I mean, can they actually make it work? I mean, some people can and do make it work. Okay, I acknowledge that. But is it viable for a lot of people? And and what effect would it have? I mean, the thing about polyamory is, what if everybody isn't on board, right? Suppose you get married to somebody and then you decide you're polyamorous.
Yeah,
but the other person isn't.
It's a problem.
Right? I mean, they're potentially coerced into. I mean, monogamy kind of protects that person. They don't have to be. I mean, the reality is actually. I mean, this is happening anyway, right? People are having affairs, right? And people are putting up with their spouses having affairs because they value the marriage, or they don't have a way out of it, But at least they have some legal protection this way. If polyamory were legal, how would we deal with the people being in different places about this? Just make that go away. So it has its complications to figure out. I mean, I'm a big fan of science fiction, and science fiction is full of polyamory. Seems like a good idea, but that's because it's working out. I mean, I'm not somebody who is out there trying to get in the way of what people want and need. That's certainly not. I didn't want anyone to get in the way of what I wanted and needed. So, I'm just sort of. I just don't have a knee-jerk kind of anything goes response. I sort of understand that these things have larger connotations, and I want to think them through. I want to see how they evolve before I'm willing to sort of put the law behind them. But I mean, there's a lot that can be done to make the legal benefits of marriage less narrow. I mean, health insurance, right? How many people want to get married so they get health insurance, right? I mean, as we've created a more open possibility of health insurance in this country, you don't need to get married to get health insurance. Well, okay, that takes away one driver toward recognition of relationships legally. Why do you need it? What are the things? What's the protection you need? If we can resolve those issues in other ways, then we don't have to necessarily change our marriage laws. People might not care.
what are some of the other benefits of having a legally recognized marriage?
Well, it can be useful for children, or you can resolve that otherwise. I mean, you can establish parentage without being married these days. There's like 1,400 federally recognized benefits to marriage, which is why the same-sex marriage cases, that's how they were argued, because there is a lot at stake. And I can't reel them off on the top of my head. But, our laws have evolved to create a lot of benefits for marriage as a way of promoting marriage and encouraging people to enter into it.
Right.
And so, that's fine. But I think we've come to recognize that not everyone gets married. Not everyone has two parents. Not everyone has a father and a mother. That people have needs, whether they're married or not.
Right.
And maybe we should be responsive to those needs. And that doesn't necessarily mean that we're undermining marriage. I think there's been a lot of concern that marriage is a frail institution.
Right.
And I think same-sex marriage has been good for marriage in that way, in the sense of making it seem more important.
Mm-hmm. Yeah.
Instead of and certainly there's a whole there's a movement within the gay community which really didn't like this movement, this attempt to get same-sex marriage, because it thought marriage was a bad institution.
Gotcha. Okay.
And it was going to pervert our relationships. And I think they still think so.
Okay.
Some of this is just about marriage.
Right.
This whole thing. Whoever it is, however many people it is.
Right. What are some of the factors that made it take so long to have same-sex marriage legalized here?
Well, I think it took a long time for society to recognize, to get over a certain kind of moralistic, religious view of it, which was really based on, in many ways, on sex itself being disgusting, right?
Mm-hmm.
Between any people, but legitimated by reproduction, right? I think that's the view
Right.
of a fair amount of religious institutions. And so, if you have a very anti-sex view, but it's made okay by reproduction, you take reproduction out of it, and suddenly you have this practice which you are not comfortable with,
Right.
and don't want to legitimate in any way. And to be honest, the same-sex marriage, the path toward the recognition of same-sex marriage started with contraception.
Right.
Because by sort of forcing states to allow contraception, and I know it's hard for you to imagine that contraception would be illegal, but it was illegal for women, not for men, because it was, it would protect them from disease, So syphilis was a justification for condoms, but not for women, and so it's really the women's birth control that was the subject of prohibitions, and the arguments it took to make that a constitutional issue, were essentially arguments. You never get the court saying sex is good. Absolutely not. They sort of got there, maybe, in the same-sex marriage cases, but still not too directly. But in those cases, it was all about sort of autonomy and the effect of denying people contraception, which was to, in a sense, say we're going to punish you by making you get pregnant.
Right.
Right. That's a consequence we want. And of course that's a position that society embraced for a long, long time. That was exactly what you needed. But eventually we realized that was not, that was a denial of women's autonomy, and that contraception was necessary in that sense. might be one thing to punish someone in one way, but to make them have a kid and have their entire life changed and,
Right.
By virtue of that was a rather different form of punishment. So, but once reproduction and sex became distinguished in the law, so that reproduction wasn't necessary for sex to be okay,
Right.
that was the first step, right? Because that's, in same-sex relationships, you can't connect. You can't say, oh, well, you could have a baby from this, right? And, there were also tortured arguments about people who got married after the, women who were postmenopausal and were allowed to get married even though they couldn't have children, or people who were infertile were allowed to get married and couldn't have children.
Mm-hmm.
Lots of work trying to explain why this was okay.
Right.
But different from same-sex couples. But it's all about that connection.
Right. Okay. For the religious organizations that were generally anti-sex, what do you think was the origin of that? And that goes back a ways.
Oh man, I'm not maybe the best person. I mean, there's some great books on the history of sex.
Right.
I think that will do a much better job explaining that. Yeah, I don't think I'm gonna go there.
Yeah, that's a big question. So I have one more question about the reference case. It mentioned the proportionality test, which was essentially weighing the negative effects of a law on religious freedom against the positive effects of the objectives of that law. Is that correct?
Yeah, I mean, that's, they have their own language to describe their scrutiny, right? We have the, sort of rational basis, intermediate, strict scrutiny, and they have this other test. I don't think it's really, I don't think in a really substantive way it's that different.
Okay.
Just a different way of describing it.
Right.
I mean, maybe in a case or two it might make a difference, but I think they're just ways of trying to describe how closely one looks at justifications for a law,
Right.
And how seriously one takes the right that's being protected.
Right.
And you could probably describe it in a million ways, but what you do, the Supreme Court does this all the time. They might say they're doing one thing, and they might actually be doing something else, right? So what you say you're doing and what you do it's what you do that's more important, perhaps, than the language you use to describe it.
Right.
But I'm no expert on Canadian law. So.
Right. Okay. My final question is about the free exercise clause. We talked about Wisconsin v. Yoder. Is there any other significant cases that'd be interesting, similar to some that we've talked about so far, that involve the free exercise clause?
Well, yeah, there's a great case. I'm going to have a little trouble remembering the name of it. It involves the. This is another case in which. The problem is that the free exercise clause has become a little less important.
Okay.
In the last 20 years, and that's because we have the Religious Freedom Restoration Act, the federal Religious Freedom Restoration Act, which was designed essentially to counteract the Supreme Court's decision in Employment Division versus Smith, the notion that generally applicable neutral laws that might substantially burden religious rights were constitutionally okay.
Right.
And so the Religious Freedom Restoration Act basically flips the burden and says, hey, a substantial burden on a religious right has to be justified in a compelling way under law, not under the Constitution, but under law. And so, many of the cases that we see now are going to involve the RFRA, religious freedom, and if you're trying to argue that something is burdening your religious rights, if you can bring yourself under RFRA, you're going to do better than the Constitution.
Okay.
Right? And so there's limited number of cases that are going to be purely constitutional. A lot of states have enacted their own RFRAs. which means, again, free exercise is not, they don't need free exercise. Just if you're claiming religious rights, you're gonna use the RFRA.
Right.
And so free exercise is gonna show up really in places where you have states without a RFRA,
Okay.
and the state is restricting the a polygamy law is the perfect example, right? Polygamy laws are not, if you're in a state without a RFRA, then the only thing that's going to limit them is going to be the state's own constitution or the federal constitution. The federal RFRA only applies to federal acts.
Right.
It can't. It was the Supreme Court ruled that the federal government couldn't reach into state affairs at that level.
Okay.
Constitutionally. So, the free exercise jurisprudence has become less important to the extent that these cases are being litigated under either a federal or a state RFRA.
Okay.
So the case I was thinking of was a RFRA case.
I got you.
And it involved a very small church that used a hallucinogenic drug. It's a church that maybe has its origins in South America, and it's a hallucinogen from that area of the world, and that was part of their religious practice, was to ingest this drug and have a deeply spiritual experience, but it's on the it's a federally banned drug,
Right.
and so they sued under the Religious Freedom Restoration Act, and the court found that an exemption should be made for them because it did substantially burden them, and making an exemption, this is the way this rule is set up, wouldn't undermine any interest the state had to protect. So letting this very small church use this drug, which was a rather unpleasant drug, makes you throw up and stuff. So it's not something that people would adopt for recreational use.
Right.
There really was no great concern that suddenly teenagers were going to be out using this drug, because it's not something that people would adopt recreationally, so it's just a completely different way of approaching these laws. Instead of saying, hey, we need to be able to have general laws and not have our social order sort of run by various religious needs, which could be extremely various, right? It says, well, if you can make an exemption for religious people, you should make an exemption for religious people.
Right.
So very different.
Okay. Yeah.
Right.
Well, thank you very much for your time today.